Hello everybody, welcome to iExamP. So continuing with the previous year question series, today in this video we are going to discuss two acts, that is Arbitration and Conciliation Act and Transfer of Property Act. इन acts में कहाँ से questions आए थे, किस type के questions आए थे वो हम देखेंगे and at the end I'll give you some other practice questions from these areas. अगर हम इनकी वेटेज की बात करें, CPC, ट्रांसफर प्रॉपर्टी, आर्बिट्रेशन, लिमिटेशन, इन चारों की एक साथ मिलकर 25% वेटेज है. Let's start. Question 1. Where the ownership of the property has passed to the buyer before payment of whole of purchase money, the seller is entitled to charge upon the property in hands of buyer for the amount of unpaid purchase money, rents, profits of property, charge upon property in hands of buyer for amount of unpaid purchase money and interest, bear any loss arising from destruction, injury or decrease, pay all public charges and rents which may become payable in respect of property. Correct answer here is C, a charge upon property in the hands of buyer for amount of unpaid purchase money and interest as well. This is given under section number 55 of Transfer of Property Act. The seller is entitled to rents and profits of property till the ownership passes. Where ownership has passed partly, then a charge upon property in hands of buyer for the amount of unpaid purchase money and interest. Question 2. Which type of mortgage is it? Where the mortgagor delivers the possession and right to enjoy an income of and from the property to the mortgagee. Simple, usufructuary, English, equitable, mortgage by disposition of title deeds. Correct answer here is 2, usufructuary. ये आपका section number 58 of Transfer of Property Act में दिया हुआ है. Usufructuary mortgage has this distinguishing feature. If the mortgagor and such mortgage is not in a position to give immediate possession, it is sufficient if he gives the right to possession. Where if a mortgagor expressly or by implication binds himself to deliver possession of mortgage property to mortgagee, the transaction is a usufructuary mortgage, although actual possession has not been delivered yet. Instead of giving actual possession, the mortgagor may direct the tenants of mortgage property to pay the rent to the mortgagee. Question number 3. A suit for foreclosure is, आप यहाँ पर स्क्रीन को पॉज करके ऑप्शंस देख सकते हैं. करेक्ट आंसर इज ए. A suit for foreclosure is a suit to obtain a decree that mortgagor shall absolutely be debarred of his right to redeem the mortgage property. यह आपको सेक्शन नंबर 67 में दिया हुआ है, राइट टू फोरक्लोजर और सेल. Question number 4. Which of the following is not a duty of mortgagee? Managing the property, must commit an act injurious to property, keep clear accounts of sums received and spent, both A and B, A, B, C. तो यहाँ पे क्लियरली दिख रहा है आंसर इज बी. मॉर्टगेजी की ड्यूटी नहीं है कि वो कोई इंजूरियस एक्ट करे. दिस इज एज पर सेक्शन नंबर 76 ऑफ ट्रांसफर ऑफ प्रॉपर्टी एक्ट. लायबिलिटीज ऑफ मॉर्टगेजी इन पोजेशन. When during the continuance of mortgage, the mortgagee takes possession of mortgage property, he must manage the property as a person of ordinary prudence would manage it if it were his own. He must use his best endeavors to collect the rents and profits thereof. Question 5. A lessor is bound to disclose to the lessee any material defect in the property. Please pause the screen, see the options. A lessor is bound to disclose to the lessee any material defect in the property. Correct answer here is D, with reference to its intended use, of which the former is and the latter is not aware, and which the latter could not with ordinary care discover. अगर आप ऑप्शंस में डिफरेंट देखेंगे तो बहुत ही माइन्यूट सा डिफरेंस है. इंटेंडेड यूज की जगह अनइंटेंडेड यूज लिखा हुआ है. ऑर्डिनरी केयर से डिस्कवर किया जा सकता है या नहीं, कुड नॉट और कुड विद ऑर्डिनरी केयर डिस्कवर्ड, ये डिफरेंसेस किए हुए हैं. तो इस तरीके के चेंजेस करके ऑप्शंस को ट्रिकियर बनाया गया है. क्वेश्चन नंबर 6. A lessee may remove his property attached to the earth at any time after the determination of lease, when he is in possession of property, before he leaves possession of property, after he leaves possession of property, A and B और C. आंसर आपका E है. या तो A होगा या A और B साथ साथ होगा या फिर C होगा. ये आपको सेक्शन नंबर 108 ऑफ ट्रांसफर प्रॉपर्टी एक्ट में दिया हुआ है. लेसर में इवन आफ्टर द डिटर्मिनेशन ऑफ लीज रिमूव एट एनी टाइम वाइल्स ही इज इन पोजीशन ऑफ प्रॉपर्टी लीज, but not afterwards all things which he has attached to the earth, provided he leaves the property in the state in which he received it. Question number 7. When can a lease be terminated? By 6 months notice if agricultural lease, by a flex of time, by forfeiture, B, C, all of the above. Answer is all of the above. इन सभी तरीकों से एक लीज को टर्मिनेट किया जा सकता है एज पर सेक्शन नंबर 111 ऑफ ट्रांसफर ऑफ प्रॉपर्टी एक्ट. Now that was all from Transfer of Property Act. Now we are moving to Arbitration and Conciliation Act. Is International Commercial Arbitration covered under Arbitration and Conciliation Act? Correct answer is yes, covered है. कहाँ पर covered है? Part 2 of Arbitration and Conciliation Act deals with it. ये आपका definitions में दिया हुआ है, इसलिए आपको पता होना चाहिए. Though Part 2 is no longer a part of syllabus. Section 2 subsection 1F of Arbitration Act defines International Commercial Arbitration as a legal and commercial relationship, and either of the parties is a foreign national resident or a foreign body, corporate, company, association or body of individuals whose central management is in foreign hands. Part 2 of the Arbitration Act deals with enforcement of foreign awards. Question 2. An application for arbitration shall be filed by defendant before submission of written statement. Option B, C, D and E. Answer is A. By defendant before submission of written statement. आप एक बार ऑप्शंस पढ़ लीजिए. करेक्ट आंसर हियर इज ए, बाय डिफेंडेंट बिफोर सबमिशन ऑफ रिटन स्टेटमेंट. ये आपका सेक्शन नंबर 8 ऑफ आर्बिट्रेशन कंसिलिएशन एक्ट में दिया हुआ है. पार्ट टू रेफर पार्टीज टू आर्बिट्रेशन when there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is subject of an arbitration agreement shall, if a party so applies, not later than when submitting his first statement on the substance of dispute, refer the parties to arbitration. Question number 3. How is the place of arbitration determined? As per the choice of parties, arbitral tribunal shall determine cumulative decision of parties as well as arbitrator at time of each hearing as per the decision of parties determined by arbitral agreement. B or D. Correct answer here is B or D. Option number 5. Section 20 of Arbitration Act talks about it, that parties are free to determine place of arbitration. If not, then arbitral tribunal shall determine it. Question number 4. When does an arbitration proceeding actually commence? The various options are given. You can read them out. Correct answer here is option number A. Request for dispute to be referred to arbitration is received by the respondent. Then arbitration proceeding actually commences. ये आपको section number 21 of Arbitration Conciliation Act में दिया हुआ है. Unless otherwise agreed by the parties, arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Question number 5. What is the language used by arbitral tribunal? Parties are free to determine among themselves. Arbitrator shall determine English or Hindi, English only, Hindi only. Correct answer is parties are free to determine among themselves. ये आपका section number 22 of Arbitration Conciliation Act में दिया हुआ है. Language can be determined by parties among themselves. Question number 6. Which of the following is part of fast track arbitration? Correct answer here is A. Parties may omit oral hearing. ये आपका फास्ट ट्रैक आर्बिट्रेशन का पार्ट है. फास्ट ट्रैक आर्बिट्रेशन इज गिवन अंडर सेक्शन नंबर 29B of Arbitration Conciliation Act. The parties to arbitration agreement may at any stage, either before or at the time of appointment of arbitral tribunal, agree in writing to have their dispute resolved by fast track procedure specified in subsection 3. Parties to arbitration agreement, while agreeing for resolution of dispute by fast track procedure, may agree that arbitral tribunal shall consist of a sole arbitrator who shall be chosen by the parties. Arbitral tribunal shall follow the following procedure. While conducting arbitration proceedings, arbitral tribunal shall decide the dispute on the basis of written pleadings, documents, submissions filed by the parties without any oral hearing. Arbitral tribunal shall have power to call any further information or clarification from the parties. Oral hearing may be held only if all the parties make a request or if the arbitral tribunal considers it necessary. Then question number 7. In which of the following cases can courts intervene in arbitral proceedings? When arbitration is completed, arbitration fails, when it is proved that one of the party was under some incapacity, arbitral order is signed. In no case can court intervene. Correct answer here is C. When it is proved that one of the party was under some incapacity. ये आपका section number 34 में दिया हुआ है, application for setting aside the arbitral award. तो अगर आर्बिट्रल अवार्ड को सेट करना है, अगर ये पता चलता है पार्टी वाज अंडर सम इनकैपेसिटी और आर्बिट्रेशन एग्रीमेंट इज नॉट वैलिड अंडर द लॉ टू व्हिच द पार्टीज हैव बीन सब्जेक्टेड टू, इन दैट केस कोर्ट में इंटरवीन. क्वेश्चन नंबर 8. ऑन डेथ ऑफ पार्टी आर्बिट्रेशन एग्रीमेंट. क्या होगा आर्बिट्रेशन एग्रीमेंट का? करेक्ट आंसर हियर इज ऑप्शन नंबर सी. शैल नॉट बी डिस्चार्ज बाय द डेथ ऑफ एनी पार्टी thereto, either as respects the deceased or as respects any other party. This is given under section number 40. Arbitration agreement not to be discharged by death of party thereto. Question number 9. An arbitration shall be deemed to have commenced on the date on which a request for that dispute is made, on date on which a request for that dispute is referred to arbitration, on the date where dispute is referred to arbitration is received by respondent, on date on which request for that dispute referred to arbitration is received by plaintiff on the date of occurrence of dispute. Correct answer is C. Same question has come earlier as well. कब commence होता है? This is as per section number 43 of Arbitration Conciliation Act. For the purpose of this section and limitation act, arbitration shall be deemed to have been commenced on the date referred to in section 21. और section 21 में बताया हुआ है arbitral proceeding in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Question number 10. The conciliator may at any stage of conciliation proceedings make proposals for settlement of disputes. Such proposals need to be in writing, need not be in writing, need not be in writing, and need to be accompanied by statement of reasons, need not be in writing, and need not be accompanied. Correct answer there is E. They need not be in writing and need not be accompanied by statement of reasons. Now this is no longer a part of syllabus. आपका section number 67 of Arbitration Conciliation Act part 2 में आता है. Your syllabus only consists of part 1 of Arbitration Conciliation Act. Rule of conciliator is no longer a part of syllabus. So this is all. In order to practice more questions from Transfer of Property Act and Arbitration Conciliation Act, you can download the PDF that is attached in the description below. अगर आपके कोई भी doubts हैं, कोई भी queries हैं, आप हमें इस number पर call कर सकते हैं. आप नीचे comment box में भी mention कर सकते हैं. Our exam भी helps you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.